We know what that music means, Jess. It's time to talk law.
Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, is with us every Thursday to offer her legal expertise by providing some general advice on the latest hot topics. Of course, having experience spanning more than 25 years in the area of property and commercial law. And she joins us now. Good morning, Despina.
Good morning, Jess. Good morning, Wayne.
Morning, Despina. Now, this is a story from a couple of weeks ago, and we want to look at it in a little more detail today. You might have heard a couple of weeks back, local Caravan Park Consortium were fined $2.3 million. Now, this is a Tweed River area. In fact, you might remember the Marine Premium Villas at Hacienda Resort right on the Tweed River. So it's a beautiful area to live, and unfortunately, people who bought here didn't always get what they paid for.
They didn't, and it's a really unfortunate case. So we have, and there's a lot to talk about, so we'll get into it. So we have a situation here where we have had a caravan park, per se, on the Tweed River, lovely area. And we, when this was developed, we had a company called Johnville Builders who were selling these villas. And then we had a park operator called Hacienda, who was then operating the park. And now, of course, the listeners would be aware there's caravan parks up and down New South Wales and Queensland coast. They do fall under the Manufactured Homes Residential Parks Act in New South Wales, and in Queensland we have a similar act, and I'm very familiar with the legislation, in fact. So this was quite interesting for me because I've been acting in this area for a number of clients and operators for a number of years, so I'm quite familiar with it. So when I was reading the case, a lot of things I was aware of straight away, and I was very disappointed to hear what had happened in this case, where we had misleading and deceptive conduct, unconscionable conduct with respect to these homeowners.
Now, these buyers thought they were buying a permanent home.
They did. So with these manufactured home parks or lend-lease communities, what you are buying, you are always buying a home. So everybody knows that. You don't buy land, you actually buy a home, and they're typically known in the past as mobile homes, relocatable homes. So, and typically they are resorts and they're permanent accommodation. So in this particular resort, it was not approved for permanent accommodation. However, the homeowners thought that they were getting a home in a location where it was permitted to be located permanently, to reside there permanently, and it was not. The council approval for the site actually provided for a period of a maximum 180 nights only. It was never approved for permanent accommodation.
That's only, half a year, isn't it? 6 months.
Exactly.
Yeah.
So these people, and I've read the case in the New South Wales Supreme Court, and when it went on Court of Appeal, I've read both cases, and it's really appalling what's happened and the evidence given, because these homeowners, as traditionally it is when you go into these manufactured home parks and caravan parks, you are traditionally a retiree and you use all your savings, or most of it, to buy a home, to stay there forever, pretty much, until you're no longer here. That is the idea. You're not there for 6 months, 12 months, 3 months. You're there as a permanent, as a permanent occupier. So in this particular case, as is typical with these types of resorts, you enter into a contract to buy the home, so a sale agreement. Then what you do is that you enter into an occupation agreement with the operator to have the right to reside there in the home that you own, because you don't own the land. Okay, so you need to have that occupation agreement where you pay site rent per week, per fortnight, etc. So this occupation agreement in this case actually had a clause that talked about the fact that you could only stay there for 180 nights.
Were the homeowners not seeing this part of the contract?
Well, this is what's astounding. So when I read the case, what the evidence that was given was that some of the homeowners came out to say, oh, look, I saw that clause in the occupation agreement, and I asked the employees of the company that was selling the villas, well, what about this clause? And they said, you don't need to worry about it. We're not going to enforce it, which is quoted in the case.
And that's the misleading part.
Misleading and deceptive conduct and unconscionable conduct, absolutely. So the Commissioner of Fair Trading took this to the New South Wales Supreme Court, and it went to the Court of Appeal because the operator appealed the decision. So the original decision was in favour of the homeowners. That is, yes, we have found the operator. There are three parties: the original developer, Johnville Builders, then the operator, Hacienda, and John Wilmot. So personally, John Wilmot was a director of both companies. He was pretty much at the centre of the whole situation. So he had obviously common knowledge, common director of both, and he was really at the centrepiece of this whole situation. So very unfortunate that this has happened, but the court found, yes, absolutely misleading and deceptive conduct and unconscionable conduct. So the operator and the developer took it to the Court of Appeal and they lost.
So that then means not only is the operator out of pocket, then whoever he worked with are too?
Yes, that's right, potentially. So what's happened here is that the court has awarded compensation to the homeowners. I think it was 2.3 million or thereabouts. And so what that means is that these homeowners spent money buying homes. I think the average value was maybe 180,000, 160,000, something like that per home. And then they incurred costs to make improvements to the home. And obviously they were there for a period of years, a number of years, 10 years. And then what's happened is the compensation is, well, I've spent my money to buy a home that I'm not allowed to live there permanently. Mm-hmm. So the operator, as I understand, will be buying back those homes, right? And paying that money out to the homeowners.
And they have to find themselves a home, move on.
Well, they do.
When you consider how much more expensive the market is for even homes like that these days compared to, say, 10 years ago.
Yeah.
These people are going to be out of pocket big time.
They will be, and perhaps the court has taken that into account. What really interested me here is the fact that the court said quite clearly that just because these homeowners enjoyed living there, quote unquote, permanently for 10 years before they were alerted to this fact is irrelevant. It's still unconscionable conduct. So I thought that was interesting because, if someone's enjoyed it for 10 years and, they could say, well, they've had it for 10 years, so why do they need compensation? Well, because they've just discovered that you misled them 10 years earlier.
Huge inconvenience.
Yeah, indeed. And that's the other thing, of course, the fact that there's more than one, so there are a number of homeowners involved in the case here, but the fact that it's over at least 10 years before anyone even noticed that there was an issue here.
That's right. So how it came about is one of the homeowners wanted to put a new carport or an extension to one of the homes. And obviously to do that, you've got to go to council. So when they went to council, a few interesting things came out, obviously. And
that clause, it was there, and they had to follow it.
Well, council obviously alerted the homeowner to the fact that, so you're living here permanently. Well, you really can't do that. So it opened up everything. And then this was an action, as I said earlier, that the Commissioner of Fair Trading in New South Wales initiated on behalf of homeowners, which was fantastic. And that's excellent for New South Wales. And these homeowners have benefited. Look, benefited not completely because, as the case said quite rightly, had they known that it was not permanent accommodation and there would never be an issue, they would never have bought in that particular park. And that is the pivotal point with misleading and deceptive conduct and unconscionable conduct claims. I would never have gone down that road had I known, had it been disclosed to me. So yes, and the fact that they had said to homeowners, don't bother about getting legal advice is,
red flag.
Well, that's a red flag in itself. It's astonishing. And unfortunately, those retirees, and I don't blame them entirely, because when you're a retiree, you are probably looking out for your pennies and you're thinking, okay, if the operator and the developer says, don't worry about it, then I won't worry about it and won't get a lawyer.
But you need that.
And incur that cost. You do. You always need to get a lawyer to look over your agreement and to give that advice to you. The operator is not there to be on your side and is not there to advise the homeowners to your benefit. They're there to sell the homes, to run the park at a profit. And I say that quite clearly. So, and I will say this though, not all operators are like this. So this particular operator did the wrong thing. I know many operators in New South Wales and Queensland who do the right thing, who do give proper disclosure, and who do insist on homeowners getting independent legal advice, which they do 9 times out of 10 before they sign the agreement. We want that to happen all the time.
And obviously, there's lots of money involved here, and in many cases it's possibly life savings for various people. You can understand those that have put so much emotional attachment into their house. They've been living there for a decade or more in some cases probably, and so it is their home. They thought that this was going to be their final home, for the rest of their lives, and suddenly they've found out that that's simply not the case.
I know, it's very sad.
Yeah,
They
yeah.
trusted them, and it's very sad. So again, I have to emphasize, go and see a lawyer, and not just any lawyer. And I will say this quite clearly, not all lawyers understand the manufactured home parks legislation or the Lend-Lease communities legislation in New South Wales and Queensland. It is very different to buying normal like houses, units where you're buying the land and you're getting title to the land. You don't get title to the land when you buy these. You're just buying the home with a right to occupy within the park. Okay, so it's very different legislation. You need to find a lawyer who is very familiar with the legislation, not just any lawyer, who can properly advise you and guide you before you sign those agreements. Really, really important. So if anyone's out there listening that might have been a homeowner in this particular resort, I dare say they were part of the class action, or perhaps in another resort, very similar, you might want to have a look at your agreements and perhaps get some advice on those documents to make sure you're not in the same position as these homeowners found themselves in.
And I know if you're thinking of a caravan park,
it's true,
maybe
that's right.
that's not an option now.
Yeah, that's the thing.
Well,
and I know you say this time and time again, but you need legal advice, regardless of whether it's a caravan park or a big home, small home, whatever. You really need to get someone to look at the contract.
You do, and these caravan parks, look, that can be great permanent accommodation for retirees, and I don't have anything against them at all. As I said, I act for some operators in Queensland, not at all, but it needs to be the right operator who will do the right thing by the homeowners and buyers and disclose properly and not mislead them.
So there could be some that actually have a permanent option.
Yeah,
It
oh,
could be.
absolutely. No, a lot of
Right.
them do. This particular one,
Okay.
council did not give approval for that. They're not all like that. Many of them, and the ones that I've dealt with, all of them have approvals for permanent accommodation. This was just one particular one that didn't. So if you're listening out there, your particular park may not have that. You just have to check it.
That's it.
So
Get that
we need
legal
to come
advice.
and see you.
Yeah.
It sounds like you're the person that specialises
Absolutely.
in this field. So 49 Cockleshell Bay. Oh, so 49 Cockleshell. What is it?
Court.
Oh, that's it.
And again.
So to come and see you. So to come and see you, 49 Cockleshell Court in Runaway Bay.
Absolutely, yes. And you can phone 55291 294.